What happens if a parent gets a second job? Would the individual be forced to have that included in the child support calculation? Would that have any effect on child support? Well, in Utah, where I practice divorce and family law, the answer is found in Utah Code Section 78B-12-203 sub 2. Quote, income from earned income sources is limited to the equivalent of one full-time 40-hour job. If and only if, during the time before the original support order, the parent consistently and normally worked more than 40 hours at the parent's job, the court may consider this extra time as a pattern in calculating the parent's ability to provide child support. If it weren't clear from the language of the statute itself, here's what it means. If the parent, 1, has a full-time 40-hour per week job, 2, is not working overtime regularly, and 3, has a second job, then child support is calculated based upon only the one 40-hour per week job. If the parent has a full-time 40-hour per week job and does not have a second job, but is normally and consistently working more than 40 hours at that parent's job, then child support may, not shall, but may be calculated based upon both the 40-hour job and the overtime. But the court is not required to include the overtime. Now, in my experience, the court usually will include overtime in calculating child support. The second job cannot be included in the child support calculation, however. Now, if the parent, 1, has no recent work history, or 2, a parent's occupation is unknown, then that parent may be imputed an income at the federal minimum wage for a 40-hour work week. To impute a greater or lesser income, the judge in a judicial proceeding or the presiding officer in an administrative proceeding shall enter specific findings of fact as to the evidentiary basis for the imputation. Income may not be imputed if any of the following conditions exist and the condition is not of a temporary nature. 1. The reasonable costs of child care for the parent's minor children approach or equal the amount of income the custodial parent can earn. 2. The parent is physically or mentally unable to earn minimum wage. 3. The parent is engaged in career or occupational training to establish basic job skills. Or 4. Unusual emotional or physical needs of a child require the custodial parent's presence in the home. If the parent does not have a full-time 40-hour per week job and has a second job, then income might or might not be imputed to that parent under a combination of both jobs. Utah Code Section 78B-12-203 sub 8 provides that income may not be imputed to a parent unless 1. The parent stipulates to the amount imputed, the parent defaults, or 2. A hearing is held and the judge in a judicial proceeding or the presiding officer in an administrative proceeding enters findings of fact as to the evidentiary basis for the imputation. If the income is imputed to a parent, the income shall be based upon employment potential and probable earnings considering, to the extent known, 1. Employment opportunities, 2. Work history, 3. Occupational qualifications, 4. Educational attainment, 5. Literacy, 6. Age, 7. Health, 8. Criminal record, 9. Other employment barriers and background factors, and 10. Prevailing earnings and job availability for persons of similar backgrounds in the community.